I wanted to introduce myself. I am Dr. Meera Singh, and I head the Amity Innovation Incubator in Lucknow. We have organized this webinar, which is dealing with the topic of investments, startup investments, its legal process and compliances. And we have a speaker, Mr. Amit Singhal, who is the co-founder and CEO of Startup Buddy and general partner of Fluid Ventures, with a demonstrated history of working in the accounting industry. He is a qualified chartered accountant with 15 plus years of work experience across varied industries. He has an extensive experience in fund administration, accounting, investor reporting, strategic planning and budgeting, forecasting, treasury, implementation of business systems, processes, and controls. He's very active as a seed investor in Indian startup ecosystem and has invested in a good number of startups like InnerChef, Kiva Life, Infido, Advantage Club, My Advo, Checkbook, TBS Planet Comics, Oro Wealth, Original for Sure, Elise, and PSafe. He has a very strong analytical and business foundation, collaborating work with different business heads across countries, and general management responsibilities have geared him as a future business leader and a great team player. His greatest strengths are his ability to develop a vision, a clear strategy, and align people towards it. As an expert in motivating people and leading a team of young professionals, he has expertise in understanding and delivering business concepts in a flashy and never forgettable manner. So I would like to introduce Mr. Amit Singhal and have him take over from here. Very quickly, I did want to mention that Amity Lucknow welcomes all startups, whether they are developing from our own students or otherwise outside. We get a lot of people referred to us by the UP government because we are a very active incubator which helps in all aspects of a startup, and helping them establish, helping them grow, and also hand-holding and funding all kinds of any services related to incubation. Mr. Singhal, if you could please.
Thank you, Meera ma'am, for such a wonderful introduction and arranging this session today. Because I personally feel that most of the ecosystem players do not understand the importance of legal and compliance part. So Amity Incubation is the one who understands that this is an important topic and given me an opportunity to discuss the same with the students and the budding entrepreneurs. So let me start with the beginning. I am not taking the initial part, how to pitch an investor and how they commit you a money. So we will directly start from the you have got a commitment from an investor. He is convinced that what you are doing and he is ready to put your money. So he will decide whether he want to invest in the debt form or in the equity form. So these are the two forms in which angel investor invests, and there is a government as well who sometimes give grants as well. So there are three different treatments for everything. In case you are taking any debt, you will have to return it with interest. So that would be very simple process where you will create a agreement with the party. You will put that what will be the terms of an loan and how much interest you will have to pay them. And after a period, you will have to return that money with interest, or there may be EMI as well, where you will have to repay that either linked to your revenue. There may be agreement where you can say that, okay, I am taking 1 crore rupees from you, but whatever will be my revenue, based on that, I will repay that money. And the it will be keep reducing from the principal, and once all the money will be returned with interest, the agreement will be over. So that can be an open-ended agreement as well. And there can be another kind of agreement where you will simply say that, okay, I have taken 1 crore rupees loan. Every month I will pay you 5 lakh rupees. So in 20 months I will repay that, and I will pay you interest as well. So that is a very simple kind of agreement. Grant is again very simple. You to participate in certain competition, government or the private body decided that you are eligible for the grant. That grant will become your income, and you will not have to repay that amount, and you will not have to dilute any equity as well. So grants of the prize money is such where you will not have to dilute your shareholding. So now we are coming to the equity funding, where investor is saying that I am investing in your company, but you will have to simply give me equity share, and I will become partner in your growth, and whenever the growth will happen, I will get my returns. So those returns you will start earning the profit, you will have to give the dividend. But normally in startup, profits do not come very early stage. So in most of the cases, angel investor want to invest with you to get an exit from the later on investment. What does it mean? That in case he has bought your equity at X price, per share price, he will wait for another investor to come who will buy his shares at Y price, which will be higher or lesser than the amount at which he is investing. So once we will cover in capitalization table, I will cover that point as well. So to understand that how much equity you are giving to the investor, we will have to prepare the capitalization table. So whenever you shake hand with any investor for the equity funding, first of all, you will have to prepare the capitalization table. What does it mean? That it will show, it is a Excel table where it will be shown that what will be the shareholding structure. So what will be the shares before the funding, and what will be the shares after the funding. And once you will prepare this statement, it will also mention that what is the pre-money valuation and what is the post-money valuation. And ESOP pool will also be mentioned here. So I would like to take an example here because this is a little complicated. So take this example. So there is an example where the startup was started by two founders. Everyone is holding equal shares, 5,000 each, and they are holding 50% equity in the company. Now one investor came who said that I would like to take 20% equity in your company. And most of the founders do this mistake. They understand that 20% of 10,000 will be 2,000 shares, and they will have to issue 2,000 shares. And sometimes founders think that they will have to transfer 1,000 shares from their own uh, bucket. But that is not practical possible because you are running a private limited company. Your private shares will not be transferred to new investor. Fresh shares will be issued to him. So in this example, 2,500 shares will be issued to him. So ultimately the revised equity of the company will become 12,500. So 2,500 divided by 12,500 will become 20% equity for the investor, and the equity of existing founder will be reduced by 10% each. So it means that even the shares will remain 5,000 each, but the equity shareholding will reduce to 40%. So you can see in this table that the Mr. A, who is the founder, he is now holding 40% shares in the company. Mr. B, who is again a founder, he is now holding 40% shares, and investor is holding 20% shares, and the total is become 100%. But as per Companies Act, new shares have been increased. It means that your capital is now being increased to 12,500 rather than 10,000 shares. In this case, take another example that investor has given 1 crore rupees for 20% equity. So what does it mean? That investor has decided a valuation of 5 crore rupees of your company, because the mathematics is very simple. In case he has given 1 crore rupees for 20%, so valuation of the company is 5 crore. But this valuation is post money valuation because he has taken 20% shares at a 5 crore valuation. What it means that your pre-money valuation was 4 crore rupees. So mathematics is very simple, that your valuation of the company will be considered as 4 crore rupees pre-money valuation. 20%, which is 2,500 shares, he has taken 20% equity. So 1 crore he has put. So 4 crore plus 1 crore is become 5 crore rupees. So pre-money 4 crore, post-money 5 crore, 20% of 5 crore will be 1 crore rupees, which is matching the entire math. So now it is a very simple case where investors can. Now let's try to make it little complicated. So here is the situation where the existing shareholders are having 5,000 shares each. So the example is same, but the investor is coming with a proposal where he's saying that, yes, I would like to put 20% in your company for 1 crore rupees, but I want you to prepare a ESOP pool as well, because you do not have enough employees or the team member who can run the company. So I am assuming that to consider this valuation, you should have a ESOP pool as well. And it was decided that 2,000 shares will be kept as reserve for the potential employees of the company. In this case, you can see that the equity shareholding has become 5,000 each for the founders, 2,000 is being kept for the ESOP pool, and now the investor who is expecting 20% against 1 crore rupees, he will get 3,000 shares instead of 2,500 shares, because the existing shareholding is 12,000 become. Important point here is that these 2,000 shares will not be issued as per the Companies Act, but still the virtual pool will be there, and you will have to consider that virtual pool in the Excel table as well as in the documentation. But once the funding will be completed, then you will create a ESOP pool document. It is called ESOP scheme. And once that scheme has been completed, then these shares can be taken care of. But for easy purpose, we can easily say that this is a virtual pool. This need not to be issued to anyone. So the mathematics is very clear that 12,000 shares were earlier, 3,000 shares issued to the shareholder, and now the total equity of the company has become 15,000 shares, 20% is 3,000. Other mathematics will remain same. Still the pre-money valuation will be 4 crore rupees, post-money will be 5 crore rupees, and the raise capital is 1 crore rupees. So 4 crore plus 1 crore is 5 crore rupees. I feel someone has raised the hand, Mr. Gagan Gupta. So Meera madam, I don't know how to accept his request. Mr. Gagan, do you want to ask any question right now?
I'll unmute him.
Okay.
Oh yeah, so I have a question. I mean, if it is correct to ask right now, I will ask now. But if you want to take up the questions, okay.
Please.
So my question is basically, so let's say if I am a founder of a startup company, I am giving a product or service related to some education domain. Why is it necessary for a founder to understand all this complexity of the finances and the complexity of the these funds and everything which you are talking about? Can't it be possible that I hire somebody who understands this complexity and work towards the simplification of this complexity so that I can focus on my business?
Okay, that is a very good question. So it is something like that. Are you in a software company or are you having some services?
Tech company. Yeah, it's a software product basically.
So is the technology part outsourced or are you doing in-house?
No, we are going to build it in-house. There are so many parts of this which will be some other SaaS products we are going to use. I think that's a different part you are asking.
That is fine. So you are in-house. So are you from tech background or non-tech background?
Tech.
So consider the situation that you come to me for investment without having any tech background, and you say that I will create a tech platform where I do not know anything, but I will outsource it to someone and someone will create it. So do you think anyone will fund that idea?
No, that is also possible. I mean, are we discussing how the startups are running and how the businesses of the startups work into the picture?
No, I am coming to that point. So I personally feel that in case some founder come to me to take my investment, I personally think that in case he do not understand the numbers, I do not invest in those companies. So that is the common thing which every angel investor. So in case they do not understand that how equity works, so I don't think that founder will be able to give me a right exit. So he will not be able to negotiate with anyone. In any case, if some startup pitch to me and afterward they say, for this matter, talk to my chartered accountant, I never take them again. That is my experience as an angel investor, and that is with the most of the investors. So in case someone do not understand the cap table, how he will run the company and how he will give me an exit. So tomorrow, if he will pitch to Sequoia or Excel kind of guy, and he will say, okay, I know the business, but talk to my chartered accountant about this or company secretary about this. I do not know anything. To be very honest, it is very rare possibility that someone will get that. So these
Okay,
are very
so
important aspects to understand that how equity works and how shareholding works. So unless until you will be clear, no one will be able to understand. My last four slides, there may be possibility you can easily say that companies that I do not need to understand because that is a part of company secretary or a chartered accountant, they will take care. But in case you do not understand the term sheet and the shareholder agreement and the capitalization table, I personally feel that the startup will fail
understood.
sooner or later.
Understood. So you are saying that these are very fundamentals that every startup owner should know.
Correct. So if you will
And
not understand
these
that
fundamentals,
how ESOP will work, how you will negotiate with your core team, how you will understand that what is the value of this equity. You know, so you will say,
yeah.
okay,
So
I will
so
give you 10% equity from ESOP. You will
no,
not understand what.
I understand. So my simple question is, we are not discussing very much complexity. We are just discussing fundamentals only till now.
Yeah, absolutely. We are
Okay,
not
cool.
last four slide. You will feel that they may be complicated for you, but you will see that in the last four slide, I didn't mention any example. One liner is mentioned, and I have clearly mentioned that this can be taken care by the consultants.
Understand.
Yeah,
Thanks.
but very
So
good question. It will give a means vision to other audience as well. So now I'm moving to the next slide, which is after capitalization table. Once you agree with your means in potential investor that how the capitalization table will look like and who will own what, then you enter into the term sheet where what is the term sheet? Term sheet is a simple document where you agree on certain items between the investor and the startups. So important point to offer that what investor is offering. That purpose of the term sheet is that investor gives the term sheet and the founders will have to negotiate it considering their points. And this is a document which is non-binding on everyone. So both the parties can sign the document, but still it will be a non-binding agreement because unless and until shareholder agreement is being prepared and it is being signed by both the parties on the stamp paper, this will be as a non-binding agreement. So the question is why people sign the term sheet. So the purpose of term sheet is to agree on the basic fundamentals discussions between the investor and the startups so that lawyers can prepare the detailed document, which is a 60-70 page document. It is called shareholder agreement, and they prepare the document based on these understanding. But still the negotiation happens at the shareholding agreement level as well. So this is not the case that in case you have signed this document, you are bound to take the money. And you must have seen various news where it is mentioned that the term sheet was signed, but still someone has backed out. So these are the very common thing. So and it is also mentioned in the term sheet itself that what will be the kind of securities. To entry of the investor, which is valuation clause. So in term sheet, it will be mentioned that what will be the valuation of a company. Right now, we have discussed that 5 crore means we have taken an example of 5 crore valuation in our earlier example. So in this clause, it will be mentioned that pre-money will be 4 crore and the post-money will be 5 crore. So another clause will be investment and milestone. So whether the investor is investing in a single tranche or will he invest in a multiple tranche. And in case it will be in multiple tranche, what will be the milestone to achieve so that he will put the next round of investment. So what will be the shareholding? So shareholding will be captured from the cap table and it will be mentioned that what is the current shareholding and what will be the potential shareholding. What will be the type of securities? So in case investor will invest, he can have a equity shareholder, which in US called common shareholder, where the rights and responsibilities of each shareholder is same, and or there may be preference shares holding as well, where there are certain preferences to the investors, or there may be different other kind of securities as well. It is called compulsory convertible debentures, where the startup issue debentures to the shareholder potential investors, and it converted into equity at a later point of time. Or there is a new concept which is called safe note. Safe note is nothing but simple agreement for future equity, where two parties sign an agreement and they clearly said that the valuation will be decided on the later stage considering your a milestone or your performance. So in case you will do Excel, then you will get Y valuation. In case you will do XT, then you will get Y thing. So that's how, in case nothing is being freezed, but two parties have decided that they will take money, or one investor has decided that he will take money. So both the parties have agreed. So in safe note, the valuation can be deferred for the future thing. Another important clause is the use of fund. You must have prepared the pitch deck where you have mentioned that I am taking 1 crore rupees for XYZ purpose. So that same thing needs to be mentioned in the term sheet as well, so that there should not be any misutilization of the fund by the founder. So it is clearly mentioned in the term sheet, either in the form of business plan or in the simple terms, that how this fund will be utilized. So it should not be the case that you have shown a picture to the investor that I will utilize this fund over the period of 12 months, but in first month itself you did all the expenditure, and then you said that I took the money, but the money is being over. So it is also being captured in the term sheet that how this fund will be utilized and how much fund can be utilized in a particular month. There are certain other conditions as well, which is called condition precedent and condition subsequent. What does it mean? Condition precedents are those conditions which required to be completed before investor give you a check, and condition subsequent are those conditions which needs to be completed after a time period of getting the check from the investor. So some example of condition precedent is that in due diligence, it is found that your GST is not being paid. So investor may say that once you will pay entire GST, which is non-compliance, only then I will give you check, or certain other things, certain pre-documentations required. So condition precedent will be required to be completed before you get the check from the investor. Condition subsequent, we discussed that it needs to be completed within 30 days or 90 days. Like he may say that once I will give you money, you are bound to give me share certificate within 30 days or 40 days, or you are bound to give me XYZ thing. So that all covered in condition subsequent. Now few next clauses are related to routine management of the company. So in case he will put the money, so what will the founders right? How the ESOP will be managed? Who will take the decisions that how much equity can be given to the employees? What will be the board composition? How many people from the investor will comprise in the board, and how many people will be from the founder side? It is also mentioned in the term sheet, and that is normally take time in the negotiation as well. Sometimes investor insist that there should be 2 board members from the investor, but founders do not want any member from the investor side to take the decisions in the routine level. So that's how it takes some times to discussion. Then what will be the voting rights between the founders and the investors? That is also mentioned in the term sheet. What will be the investors' right? What are the restricted items? Like in most of the cases, it is mentioned that whenever companies are hiring anyone where salary is more than 15 lakh rupees or 12 lakh rupees, they need investors' approval. So all those restricted items are mentioned in the term sheet. It may be like starting a new kind of business which was not mentioned in the pitch deck, or maybe creating a subsidiary of the company or demerger of the company. So there are certain clauses which are mentioned, and these are restricted. So it means that it does not mean that you can't do it, but for doing that you need investors' approval. And there are few clauses which are related to exit, that in case of exit, what will be the liquidation preference, who will get money first and who will get later, and how much money will be distributed and how it will be distributed. In case some person want to transfer his share, what will be the process of those shares, and what will be the exit strategy, whether it will be kind of IPO, and in case founders will not able to give exit within 7 years of the investment, what will be the right to the investor to get the right exit from their own. So these are certain clauses which are very important and normally mentioned in all kind of term sheet. So I have covered only basic point, but there is no template of term sheet. It can be of any form, and any point can be covered which founders and investors feel that is necessary for their understanding. Once the term sheet is being prepared, that is being given to the lawyer, and he prepares the shareholding agreement. Before moving to the next point, I feel that there are some hand raised. I would like to take questions on the term sheet right now.
Sir, we have Sudeep Kumar raising his hand. I'll unmute him.
Sure.
Hello.
Yeah, Sudeep.
Yeah, I just wanted to have some guidelines on valuations. On the 7th slide, the first point, the valuations of a startup.
Sure. It is the same thing. Like when investor and founder have decided that what will be the valuation of their company in the capitalization table, just I mentioned, where investor is putting 1 crore rupees for 20% equity, it means that the valuation of a company is 5 crore rupees. But that has been
Is there
told
any
as
formula? I just wanted to know, is there any preset rule or is there any techniques?
The techniques are available, but those techniques are not easy. Means entire session is required in the valuation itself because it is based on various factors like at what stage you are. Are you at early stage or later stage? What is the market size? How much market you can capture? What is the growth potential there? How many co-founders are there? Are these co-founders having complementary skills or not? So there are certain platforms or also which are coming up to do the valuation, but that is not the case that where I can give you a simple formula. But for series A kind of thing, the formula is like what is your top line and what is the multiple of that. Like in food and beverages, whatever is your annual sale, you can multiply it by 5 or 6 kind of thing, and depending upon the founders background, etc., the valuation is being freezed somewhere between 5 to 7x. But that is related to series A or series B kind of thing. For the early stage, it is purely depending upon the potential of the company, that how big, how good picture you can show to the investor.
Okay, okay, okay. Thank you. Thank you.
Okay.
Uh,
So, yes, I.
Ms. Asif Mirza.
Okay. Yasir.
Hello.
Yasir. Good
Yeah,
afternoon.
hi sir. My name is Asif and I'm from Ethigate. See, I have a question regarding the valuation for the company. See, I have got a company and I have made certain transaction like up to 5 lakh rupees. The revenue we have generated, and we are a technology-based startup. So how the valuation will be done, and things will work in that case.
I feel that this is a repetition of question. So Mr. Sandeep also asked the same question where I mentioned that it
No,
is
but we
dependent.
have completed like certain period of time, and we have generated certain amount of revenue also. And we are a technology based startup. And in this case, see, we have a we when we started, we have a very basic app. It's a security app, and now we develop on a certain level. Whereas if somebody will go and develop that product, it will cost like 50 lakh rupees or 60 lakh rupees for both Android and iPhone. So in that case, how the valuation will be done, on what basis?
So my answer will remain same that
Hmm.
it will need detailed analytics. It is not a 5-minute job where investor and founder will have to sit on the business plan.
Voice is
We will
breaking.
have to understand that what is the background of the startup founder, what is the background of startup founders, and what is the growth potential in this company, and what will be the potential of this company after 1 year and 2 years. So that is a very detailed exercise. It can't be done like that, that in case we will cover these 2 3 points and I will be able to tell that okay, the valuation should be 2 crore or 10 crore or 15 crore. It is purely
Okay.
depending upon the investment required and what will be the ROI of that company, and it
Okay.
needs a business plan in detail which will demonstrate that what should be the right valuation.
Okay. All
Because
right. All
5
right.
lakh, you can't go in the market by saying that I have a revenue of 5 lakh rupees and I will get the valuation as a multiple. You will get a negligible valuation because the growth potential is heavy. And in case you have reached at a stage where the growth potential have been reached and there is not much opportunity to grow more, then you will enter into the multiple kind of thing. So right now
No.
it will be a detailed exercise for your early stage. But still, I will
Okay.
request, because the topic is being legal aspect right now, so I would like to restrict myself for the benefit of others. Still, I will take your questions offline. So I will give my email ID in the next last slide, and we can
Okay.
take that question as well. But right now, I would like to focus only on the legal aspect.
Okay. All right. Okay.
Yeah.
All right. Okay. Thank you.
So once the term sheet will be, so now I'm moving to the next step. So once the term sheet will be signed, then due diligence will be initiated by the investor. The due diligence may be of 4 types. One is operational due diligence, where he will sit and understand your operational aspect and will understand that whatever you have pitched to him, is it fine or not, and is it doable or not. So operational due diligence is one thing which investor get it done from outside party. Another is financial and compliance due diligence, where they want to understand that there should not be any liability towards the government which has not been paid yet. So financial and compliance due diligence is also part of the due diligence. And the third due diligence is legal due diligence, where they ask you to share all the agreement with anyone, even with employees, with the customer, with the vendors, or any third party, or even with the landlord, etc., to understand that how good you are into the legal aspect, or is there any loophole where you can stuck sooner or later. So the lawyers read these agreements and understand that there is no exposure. And in case you have some patent or IP, etc., like trademark, they ask for the documentation and check if that IP is in your name or company's name or not, and they want to ensure that it is properly protected. So these are the four kind of due diligence which happen just after the term sheet. And once the due diligence happens, investor ask their lawyer to convert the term sheet into shareholder agreement. The clauses of the term sheet will remain same, but the simple language of simple English language will be converted into the legal language, and it has become a detailed document where it will be backed by certain examples as well, that in multiple scenarios how these clauses will take impact. So that is the next step. Once the investment agreement is being prepared and it is being signed by both the parties, investors as well as founders, then the compliances related to Ministry of Corporate Affairs will be started. It is called MCA compliances, where a special resolution will be passed to increase the capital, and the offer letter is being shared with the potential investor. The offer letters and will submit to the company. Take that money in your normal bank account, because there are certain rules applicable where you can't utilize that money unless and until you do all the compliances. So there can't be scenario that 10 investors are investing in your company, 2 have given your money and 8 are pending, and you start utilizing their funds. That is not possible. So you will have to keep that money in the separate bank account. Till the time entire round is being closed, you can't utilize that. Where you will allot the shares, and after allotment of shares, you have to file PAS 3 with the Ministry of Corporate Affairs. Once that document is being filed with the ministry, you have got the acknowledgement and you have paid the necessary fees, then only you can use that money. In case you fail to complete the round within 60 days, you will have to return the money back to the investor. So it is also necessary that whenever you receive the money, you will have to allot the share within 60 days. Print the share certificate and will have to share through courier or through by hand to share certificates can be issued in the two form. One is in electronic form, which is called DMAT form, and one is physical share certificate. So in case you are issuing physical share certificate, you will have to pay the share stamp duty, and it is different in each state. So there may be possibility that in Haryana you are paying 0.1% of the amount received, and in Kolkata it is purely 1 rupee irrespective of the fund raise. So it is purely depending upon the state that how much stamp duty is applicable. And in case you are issuing in DMAT form, no stamp duty is required, because that law is applicable only in the physical share certificate. So once this is being done, you are through, means your entire compliances are done. But in case you have any investor who is investing from outside India, then you will have to do certain FEMA compliances as well. So what does it mean? You will have to submit certain documents to RBI to mention that this is a capital transaction. So why RBI come into the picture? Because whenever any money come from outside India, RBI captured it in their records, whether that is a revenue for the country or that is an investment for the company. So they will even if you do export, then also RBI capture it that okay, we have received $1,00,000 from outside India, but that is a revenue of India, and they capture it under the export services and they report like that. But in case you are getting some funding against equity, so RBI also want to know at any point of time that how much investments are done by different countries to India. So they ask you that whether the valuation is correct. So they check it as well. So there should not be the case that you have issued share at a lesser valuation. So they check your valuation report, which is being prepared by a merchant valuer or the chartered accountant. They check the compliances as well, that properly share certificates are issued to them or not. And they ask for a company secretary compliance certificates as well, which certificates tell that yes, all the compliances are being done on time, so no penalty is being levied. So RBI do not do it themselves. They have delegated this power to the bank. So in whatever bank you receive the money, those are responsible to do these compliances, and they are responsible to check these compliances on behalf of RBI. So you will have to submit the documents online on RBI website. It will by default go to your banker, which is called authorized dealer, and authorized dealer will have to give you a clean sheet. He will issue a unique identification number for that transaction, and once you will receive that unique identification number on your email, that transaction is being completed as per FEMA compliances. So FEMA is nothing, Foreign Exchange Management Act, and it applicable on all kind of transactions in India, whatever is the cross-border transaction. So this is discussed. You can take the photographs as well. So we have discussed about these 10 points, which are the process related to legal and compliance part of the fundraising. So now I'm opening the floor for the questions. I can see many hands are raised, and even if after taking my questions, if I will not be able to take certain questions, you can write to me at info@startupbuddy.co.in. I will try to answer you on email. So Sahil, whosoever want to ask question, now I'm done with my presentation.
Sir, so we'll start with Dr. Sanjeev. I have unmuted him.
Sure.
Hello, Mr. Singhal. My name is Dr. Patni. I'd like to ask a very simple question in continuation to what others have asked, but more focused on the legal aspect as you are more inclined towards it. That apart from all the kind of compliances which are of legal kind and which are statutory and maybe process oriented to be complied by another third party or a consultant, the only point of contention is about the valuation. Now, as far as I understand, the valuation is guided by the IBBI certified valuer, because he wants a certain number of documents like discounted cash flow or any other kind of parameter to certify the valuation of the organization at that particular point. And that becomes kind of a valuation which the ROC will approve or the MCA will approve. And otherwise, that is not acceptable by ROC or the MCA. Now, it can be either an IBBI certified valuer or a merchant banker, one of the two. Is that correct to assume?
To be very honest, in India, what has happened, so different department has mentioned the different kind of accountant. So what the income tax says that this certificate needs to be certified by the accountant. And the definition, which was earlier merchant banker / chartered accountant, so income tax has removed chartered accountant word from there. So from income tax perspective, because section 56 is applicable here, which give right to the assessing officer to check that the valuation is correct or not. So chartered accountant is being removed. So for income tax perspective, you need a merchant banker. For Companies Act, you require registered valuer. So now registered valuer course is also being started. So people have now becoming registered valuer. And RBI says that it can be either from the merchant banker or it can be from chartered accountant. So now the best way to take it is that the chartered accountant who is a merchant banker also, who has a registration with merchant banker, so we are taking certificate from him only, so that it will serve both the purposes. It will serve purpose of income tax as well, and it will serve purpose of RBI and Companies Act as well.
So to understand your point, it is not a discretionary matter that between two people, that my valuation is this much and therefore the other person has to agree or should agree to that valuation. There is a process behind, and which has been well prescribed by the government, even by ROC as well as the income tax department and the MCA, and therefore if those are not complied with, then there is a kind of problem with the income tax department under 56A, as well as by the ROC or the MCA. So there's a process
Absolutely.
behind. So it's not discretionary as you put it earlier.
To be very honest, there are two aspects. One is practical aspect, and one is the documentation part. So
Okay.
whenever two people negotiate on certain things, like even take an example of property, there may be possibility that I saw your house, and I saw that the worth can be 3 crore rupees, but still the circle rate may be different for them. So
Right.
there is a absolutely differentiation between the practical aspects. So in term sheet, two people negotiate between with each other, and then they reach out a conclusion what should be the valuation of the company. Then from documentation perspective, they understand that the valuation is correct or not. And if it is not correct, what is the wrong assumption behind it? Because the DCF calculation is purely based on the assumptions. So what will be your 10-year assumption? What will be the growth? So even if you will reduce your growth from 20% to 18%, your valuation will change drastically. And even if you will change the interest portion, so your present value will change. So if RBI will reduce the interest rate from 6% to 5.75, you will have to change the present value of all the businesses. So your projection will remain same, but your present value will change. So DCF is very subjective. So in practical terms, no one negotiate based on the DCF method. So first negotiation happens based on certain parameters. Then consultant create the valuation report based on the assumptions.
Okay. I mean,
So this is
what you're
a kind
saying
of this is a
procedural
kind
part.
of backward calculation.
Yeah. But I mean, still to be compliant with the ROC as well as the income tax, and not to face the backlash of 56A, it is recommended that
but still I can give you a contradictory view. In case you will register yourself with the Startup India, then you will be out of angel investment tax.
see that is one point, but still you can't be away from the ROC or the MCA.
That's fine.
I mean, they would have they would not accept the pass-through if there is if there is no report from the IBBS certified valuer or the merchant banker. They will not accept it.
Again, it depends that in case you are taking from non-resident, then only RBI will require it. Income tax will also, there are certain pros and cons. So I am not saying that valuation report is not required, but again I am repeating that from founder perspective, it is not necessary for any founder to understand that what is the DCF method. No investor will ask the DCF method, but definitely they will require that report from the consultant. No question about it, or no doubt about it.
Okay, thanks.
Sir, we'll be taking some questions from the chat. So we have Karan Gogia. Can we raise FDI with safe note? Because in FDI, we need to declare the value upfront for CCPS or any other convertible security.
Practically, I don't think that there should be challenge in raising funds through FDI. But from practical aspect, I will suggest that you can write mail to me. I can check with my expert team. I will not be able to answer this upfront.
Okay, sir. So we have another question from Suraj Verma. Is there same MCA compliance after receiving the grants?
No, I don't. There is no MCA compliances required for the grant, because grant will be simply become your income unless and until it is being paid by someone as a loan. So in case there is a loan, you will have to do certain compliances depending upon the clauses mentioned in the agreement. But in most of the cases, it has become your income directly, and that is a tax-free income. But in case you are getting soft loan, that yes, you will have to do minor compliances related to MCA, that is related to agreement portion.
So next we have Gagan Gupta raising his hand. I'll unmute him.
Sure.
Hi, Amit. So my question is, for example, there is a product called cleartax.in, which simplify the process of filing up your tax and filing up the income tax returns online. Do you know any product in the same category, like we are talking about the compliances and the legalities for the startup funding and the finances? So can there be any product or service you are aware of which I can use and the other people in my company, co-founders, everybody can use in this regard?
So right now, no product is available, but ClearTax itself is sharing blogs on these topics. But I personally feel that AngelList is coming up with this kind of product, because in
Okay,
US there is a product called Cereta, CERTA, which is very famous, and it has become multi-billion companies there, who is helping in entire processes related to term sheet to the current valuation as well. So it is a kind of
exactly.
portfolio management company for the investor. Angel List is the one
Okay.
Utkarsh recently announced on LinkedIn that they are coming up. They have come up. Means that is a very initial stage, but once it will reach at the next stage, I think these points will also be covered automatically.
Okay, Sarata is one. Can you give more examples if, or otherwise you can take it offline as well?
No, I know about CETA only because I have heard that name only from everyone. So I
Okay,
don't think even if they have any competitor or not in US, because most of the
mhm.
companies, all the companies are using CETA only.
Okay. So as per the guidelines of the Indian government and the standards which we are following for the startup compliances here in India, there is no product available, right?
Right now, no, because every lawyer is creating shareholder agreement depending upon the negotiation between two
I
parties.
understand. I understand. Thank you.
So we have a question from Rishi Saluja. I'll unmute him.
Yeah, hi Amit sir, this is Rishi. Thanks for the information that you have provided today. It's really helpful. I just have a simple question. We actually have talked about the investors, like how they are interested, what would be the right composition when you're writing about the shares and everything. That's very helpful. I just have a small question regarding the exit. So generally this happens that when we are talking about the terms and conditions, certainly there would be some points which investors are looking forward as an exit criteria, which are suitable for them. Can you just highlight some of them which would be useful for us?
So criteria will be very simple. Like one thing I mentioned, that it will be liquidation preference. So whenever some exit will happen, so they will say that in case there is a down round, so definitely they will get money first before you. So founder will get the money last. And even if there are multiple rounds, so the person who has invested later, he will get the money before the earlier investor. So because this is the case that every time whenever you create the agreement, everyone's want preference rights rather than earlier one. So they have a upper hand because they are putting the money. So liquidation
All right.
preference is the one thing which is very important. Apart from it, this is a very common clause that in case you will not be able to give exit to the investor in 5 years or 7 years, they will have right to sell their shares at their own discretion at any valuation. So these are the clauses mentioned. Apart from it, there is a clause which called like drag along or tag along. So in case they want to sell their shares and you are not getting any buyer and they are getting buyer, but he needs certain more shares, then you are bound to sell your own shares as well. ROFR is something, means there are certain clauses. I didn't enter into the complexity intentionally, but liquidation preference and the 7-year clause that where they will come into the picture for an exit. These are the important clauses which every founder should read very carefully.
All right. Thank you so much, sir. I think so. I'll connect you over the email because I have some more questions, but again, it would
Sure.
take us into the complexity. So it would
Yeah,
be better if we talk
anytime I will connect you with my expert team. To be very honest, being a CEO, I know everything, but the complexity part take care by my team.
Yeah, sure. Thank you.
Sir, we have a question I could not find. What is the name of the company? Cereta, Harinder Bhatia. Could you please clarify what is the concern you're talking about? I'll unmute you.
I unmuted myself. So, Mr. Harinder, I know you are also angel investor from US. So SETA is the one who take care of the investors there in US to create the portfolio there. So it is similar to moneycontrol.com or a demat account in India, where any startup who is investing equity to their shareholders, they can use SETA platform and they can issue securities in electronic form to the investor itself. An investor can see the current valuation at any point of time, that how its portfolio is performing, and even if they will have to submit the MIS, they simply upload it into SETA and it is accessible to all the investors who have invested in their company. So whatever are the updates to say, so they simply update that in that platform.
Hey Amit, can you hear me?
Yeah, I can.
Yeah, I just wanted to know, how do you spell the word SETA here? I tried to look it up and I couldn't find it in Google.
Let me say send offline. Let me see.
Yeah, okay.
I will send.
Yeah, thank you. That's it.
So we have another question. Again, I think this is again related to the same SETA query. This is from Gagan Gupta. If I think I'll unmute Gagan also, in case if they wish to speak directly.
Oh no, that's okay. I think I have asked my questions.
Okay. Just wanted to inform all the attendees, we're coming up with a session on that is on ease of doing business. That is also something related to startups, LLP versus a private limited. So I'll just share the link in the chat. So in case if people are interested, they can register for the event. I'll also share the screen for the event creator. Just a minute. So this is the session. The session is from 3 to 4 p.m. and this is the session which would have incorporation allied compliances, LLP versus private limited, legal and finance, investment or expense, and followed by a Q&A. So now I would hand over to Dr. Meera Singh for a final note.
First of all, I would really like to thank Mr. Singhal. It was very informative what you shared with all our incubatees and prospective startup owners. All of them need this kind of information. And I would also like to invite you, Mr. Singhal, to become one of our mentors for Lucknow AII.
Anytime.
Because it would help. I think a lot, some of the startups, of course, are too shy to ask questions. And so I was thinking one-on-one, questions, just a phone call, anything. If we can arrange that, that will be much more beneficial for some of our I won't call that, all our incubatees mostly.
Anytime, and I keep going to Noida property. I can see that Mr. Jaising also raised the hand, but I don't know what he wanted to say. So I will be happy to accept the invitation to become mentor for Lucknow as well.
Yes, because I think this all the stuff you were discussing is very helpful, but like who was it? Gagan was asking questions in the beginning. It's a little beyond some of them to just grasp all of it in one session. So as they come up with questions, well, they're setting up their company or they are, getting investors on board, any stage of it, it will be good to be able to talk to you. And other than that, I think this was excellent. Thank you so much for, giving us the time, and we'll stay in touch.
Yeah, in fact, it's a pleasure talking to all the audience, and thank you very much for giving me an opportunity. And at the final, I got the spelling of CARTA as well. It is CARTA.com, so people can go there and understand that how US is very advanced in terms of this legal documentation. So thank you very much again for giving me an opportunity, and thanks all audience for patiently listening.